Hello, I am Dr. Manvendra Kumar Tiwari, and I am an associate professor at the Dharmshastra National Law University, Jabalpur. Today, continuing our discussion forward in legal reasoning, we'll discuss about the relationship between law and morality. Here, we will be discussing the relationship between law and morality through the prism of the state-made law, in the sense that how a law made by the state, so far as the recognition questions of law is concerned, keeps the moral questions about the law outside the confines of law. So this is what we will discuss. I'll explain as to how the state ensures that the moral disagreements with the content of the law made by it have got no bearing on the identity question of law as law. Now, the study of law as science argues that law is, like science, amoral or non-ethical. Now, state follows this logic of equating law as science. And as is the case in science, science is truth, and truth is not moral or immoral, ethical or unethical. Truth is amoral or non-ethical, because you don't judge truth as to whether the truth is morally right or ethically right. The truth is truth. So therefore, if that is what the state tries to do when it comes to understanding the nature of law. So law is law, not because of the content that it encapsulates or it it has, but law is law because it has been recognized as law by the state. So by this way, the state is able to take away the moral disagreements about the content of law as something which has got no bearing on the identity of law as law. So law is law not because the content of law is morally right or morally just. Law is law because it is a state-made law. So in that sense, the truth about law becomes amoral or non-ethical. So following this logic, the state gives legitimacy to its laws. Laws are law not because laws are morally right or just. Laws are law because of it being simply law. The law is law because law has a definition and identity ascribed to it by the state. So because the state determines what becomes law, and therefore state has the authority to get the recognition of a law made by it as law. And by doing so, the state is able to keep away the moral disagreements or disagreements about the content of the law that it has made from the debate as to whether the law made is law or not. Okay, so that's a very important understanding, and that also in a way tells us the effect and the authority, the all-encompassing authority which the state possesses to make and identify and recognize law as law. So death penalty, for example, is a valid punishment because the legislature has prescribed it, and even the Supreme Court of India has upheld its validity if it is given in the rarest of rare cases. So this is a case of death penalty being a case of prescribed by the legislature, validated by the judiciary, and both are the organs of state. So therefore, death penalty is valid, not necessarily because it is valid in a sense, but because two organs of the state, namely legislature, has prescribed it, and the another organ of state, namely judiciary, has validated it. and both are able to do so because of the power, the sovereign power that they have on account of being the organs of state. Those who oppose death penalty are not proven morally wrong, but they have been proven legally wrong, because what is legally right and what is legally wrong is entirely the domain of state. So therefore, those who oppose death penalty are not proven morally wrong, but legally wrong. But the state must accept their argument. Only then the death penalty can be abolished. So if those who oppose death penalty uh, want death penalty to go, the only way that this can happen is that when the organs of the state would accept their argument. But when they do so, again, it is because of the decision of these organs of the state to alter the law on death penalty that the law on death penalty is altered. So this way, again, the disagreements about the content of law have got no bearing on the question about law being law. So law can validate death penalty and it can even abolish it as well. Both the forms of decisions about death penalty will be valid. That again, in a way, tells us the the the, the authority of lawmaking which the state possesses. That state can even make a law to take away someone's life, and that will also be a valid law. And at the same time, state can even decide to abolish death penalty, and that can also be a valid law. So that way, moral disagreements, especially in case of death penalty, have got no bearing on the question, it seems, and that it is entirely up to the state what it wants in respect of the punishment of death penalty. Now, following this logic is an ought-law distinction is also to be understood. Only is law is law. What is law? Is law is the law that exists on paper made by the state. So only is law is law. So that means any disagreements with the content of that is law does not mean that the is law has ceased to be law. A moral critique of law happens outside law, and therefore the morally imperative oughts are not law. Therefore, an immoral law is also law, nevertheless. So that is the outcome of this kind of arrangement. So that is why we may find, some of us may find, that a law is actually immoral and actually unjust. Yet we also find that immoral or unjust law continues to be law. Many a times, example from the Indian Penal Code or Bharatiya Nyaya Sanhita in the form of marital rape exception is cited as an example where an immoral law or even an unjust law nevertheless is law. However, the constitutionality of this has been challenged, and it is presently pending before the Supreme Court of India, which will decide as to whether uh, this is a correct prescription coming from the legislature or not. Now, whether laws are amoral, that's an important question to know, because though we saw that the state, because the state has got the authority to make and recognize law as law, so the state is able to create that divorce whereby moral disagreements about the content of the law that it has made have got no bearing on the identity question of law as law. Law remains law irrespective of howsoever immoral or howsoever unjust it may be. But the question is, we are actually trying to understand the question whether it is actually in a sense amoral. Okay, and as it is clear, oughts are the moral imperatives. Oughts, when become law, become is. That's right, because even the laws that the state makes does not come from vacuum. So the state wants that a certain content that it feels to be good enough or pressing enough to be included within the fold of law, state comes up with is law, where that ought is converted into is. But the question is, whether this conversion of ought into is makes that is an amoral law. Now, the answer is that at the most, it is a moral law validated by the state. But because the state has got the exclusive authority to make and recognize law as law, so the state is able to create that facade whereby the ought nature of law is erased so far as the identity question of that law as law is concerned. So we recognize that law as law because it is in the form of law, and therefore its content, howsoever morally imperative and howsoever morally abhorrent that may be, that becomes inconsequential so far as the recognition of that law as law is concerned. But this is happening squarely because of the power which the state has. In a sense, it remains a moral law because it is the state finds it to be morally right to come up with that law. The problem being that the state cannot just say that it is law because state considers it to be morally right. The state has to make it part of the formal lawmaking by way of legislative enactments. And that legislative enactment has the force whereby the moral disagreements with the content of that law fall outside law. But that does not make the content of is law an amoral content. It remains a moral content, and therefore moral disagreements about the same is possible. Yes, because of the power of the state, the moral disagreements will be falling outside the confines of law, and that will have no bearing on the identity of that law as law. But in a sense, it is wrong to say that a state-made law is amoral. It is amoral only to the extent that because of the power of the state, the moral disagreements fall outside the confines of law. Okay, but in a sense, it remains a moral content. Moral because the state considers it to be morally right. So this is a very interesting discussion that you will that the law students generally study when they start studying jurisprudence, when they are introduced to the school of legal positivism, wherein they are told about the impact which the black letter law ordained by the state creates. Now, we will see a few questions based on the discussion that we had. So the first question, the study of law as science treats law as amoral. The study of law as science treats law as amoral. So option C is the right answer. An amoral law is morally neutral. Yeah, that is what the claim is, that if the law is amoral, it has to be morally neutral. So there are no moral disagreements about it. So option C is the right answer. Morality of law makes law content neutral, moral, immoral, content neutral. If the law is amoral, its content is neutral. And that is what is the claim of every law that the state makes, that the content of it is neutral because law happens to be amoral. Laws made by the state are law because such laws are morally right. No. Immoral. No. Made by the state. See, laws made by the state are law because such laws are made by the state. So therefore, option C is the right answer. Law is law because it is defined and recognized as such by the state. Law is law because it is defined and recognized as such by the state, not society, international community, or domestic community. So option C is the right answer. As per the state-defined law, the moral critique of law happens outside law, not inside law, not outside justice. So outside law. The moral critique of law happens outside law. So option B is the right answer. Whether an immoral law can be law? Yes. In an immoral law can also be law because the moral critique of law is outside law. So therefore, It gives rise to the possibility that a law which is law can actually be immoral. And that's why whether an immoral law can be law, the answer is yes, option B. Whether an unjust law can be law, again, following the logic of question number 7, yes, an unjust law can also be law, because the argument that a law is unjust is again a critique of law from the point of view of justice. And this critique is also outside the confines of law. And again, as a ramification, even an unjust law can be law. And that's why option B, yes, is the right answer. Is law is made up of oughts, but is law because it is, not because it is a moral imperative, not because it is ought. It is because it is. So option B is the right answer. And the last question, whether in a sense the state's law is amoral. We just saw, in a sense, the state's law is not amoral. It is moral, considered moral by the state, and state is able to create that facade of immorality because of the exclusive power that it enjoys of making law. And therefore it is wrong to say that in essence also the state's law are amoral. So the answer is no. In a sense, the state's law is not amoral. So option A, no, is the right answer. So thank you very much.